So imagine being arrested for second-degree murder. Like you are staring down the very real possibility of spending decades in a concrete cell.
Right. Yeah, I mean, your whole life is basically over at that point.
Exactly. But as you look around at the circumstances of your arrest, and really at the cascading failures of the local justice system that put you in that position to begin with, you decide to make a move that sounds like it was ripped straight out of a Hollywood screenplay.
Oh, it really does.
You decide that the system is just so profoundly broken, your only logical recourse is to run for the job of the very sheriff who just slapped the cuffs on you.
You don't just put your name on the ballot as some sort of like a symbolic protest vote,
No, you run and you actually win the primary election in an absolute landslide, completely unseating a 13-year incumbent.
which is just wild.
Yeah. And then, just as you are gearing up for the general election, while simultaneously preparing for your own high-stakes murder trial, by the way, the murder charges are suddenly and entirely dropped.
Out of nowhere.
Right. And why? Because the police department, the very agency you are currently running to take over, somehow managed to lose the single most crucial piece of digital evidence in your entire case.
Is a sequence of events that, it naturally makes you want to check the sources twice.
Yeah.
The irony is just so thick it feels entirely fabricated.
But I assure you, it is not a script. This is playing out right now, in real time, in Little County, Arkansas.
Yeah, the Aaron Spencer case.
It's astonishing. And unpacking that case is our mission for this deep dive today. But real quick, before we get into all that, if you enjoy these deep dives, please take a second to like this video and subscribe to the channel. It really helps us out.
It definitely does. And speaking of updates, we should probably cover the mandatory legal update we have right now.
Oh, right. The Martin Stevens versus OpenAI situation.
Yeah, so just a quick note for everyone following that case.
Yeah.
We are currently in a designated quiet period regarding Martin Stevens v. OpenAI. So, pursuant to the ongoing legal proceedings, we won't be providing any new commentary or analysis on that specific litigation until the quiet period officially concludes. Just wanted to get that out of the way.
Perfect. Thanks for the update. So, all right, shifting back to Arkansas. We have gathered a pretty massive stack of source material to get to the bottom of this sheriff situation.
We really have.
We are looking at local news reports from Arkansas. We've got these incredibly detailed legal summaries breaking down self-defense statutes provided by U.S. Law Shield.
Which are super helpful, by the way.
Very. Plus, we're pulling in historical data on the evolution of the castle doctrine, and we have the absolute latest court updates that just dropped literally yesterday in June of 2026.
And I think the goal here is to take all these disparate pieces, right? The arrest affidavits, the complex legal theory, the wild procedural history, and synthesize them.
Because it's a lot to keep track of.
It is, because what we are really looking at here is a massive collision between raw biological parental instinct on one side and the incredibly strict, almost clinical legal definitions of self-defense on the other. And it's all playing out within the often chaotic reality of a local justice system.
To really wrap our heads around this, I think it helps to view the legal system as a sort of pressure cooker. Like, you and I and everyone listening, we all implicitly agree to live inside this cooker.
Right, the social contract.
Exactly. We hand over the monopoly on violence to the state. We give them the authority to arrest people, to hold trials, to hand down punishments. But in exchange for giving up that power, the state makes us a promise.
A very specific promise.
They promise to act as a release valve. They're supposed to keep the pressure manageable by stepping in, dealing with predators, and protecting the vulnerable. But what happens when the state essentially welds that release valve shut?
The pressure has nowhere to go.
Right. It just builds. When the legal system fails to protect someone's child, it backs ordinary citizens into a corner, forcing them into these unimaginable split-second decisions where the only real options are to become a victim or to take matters into their own hands.
And that tension, that is the core of this entire narrative. The law strictly demands that you wait for the authorities.
Right.
But biology strictly demands that you protect your offspring.
And when those two mandates contradict each other,
the results are literally explosive.
So let's examine the specific circumstances that lit the fuse here. The timeline brings us back to October of 2024. And we need to establish the backstory because it is harrowing and it's the foundation of everything that follows.
Yeah, it's tough to hear, but it's essential context.
We are looking at a 67-year-old man named Michael Fossler.
Right. And according to the legal reporting we have, Fossler had initially met Aaron Spencer's 13-year-old daughter through a mutual family friend. And over a period of time, he allegedly engaged in a systematic process of grooming her, which was primarily happening through text messages.
Which is terrifying.
It is. By the time we reach October of 2024, law enforcement had actually intervened. Michael Fosler had been arrested and was facing a staggering 43 separate felony counts.
43 felony counts. And this is all involving a single 13-year-old girl. I want you to process the gravity of that number for a moment.
It's massive.
Mm-hmm.
To contextualize what 43 counts actually looks like within the criminal justice system,
Mm-hmm.
I mean, we are not talking about a single misunderstanding here or a one-off allegation.
No, not at all.
The charges included indecency with a child, internet stalking of a child, and the possession of illicit material. A charge sheet of that magnitude indicates repeated, documented, and highly specific predatory behavior.
It's a clear pattern.
Exactly. When pretrial services and judges look at risk assessment matrices, a profile like this traditionally lights up every single red flag for potential reoffense.
So logically, you would assume that a man facing that kind of severe predatory rap sheet is going to be locked away while he awaits trial, right? You'd think the system would look at those 43 counts and conclude that this individual poses an active, ongoing threat to the community.
Especially to this particular child.
Right. But this is where we see the first catastrophic structural failure in this case. A judge named Barbara Elmore presides over Fosler's bond hearing, and her decision is to allow him out of the county jail on a $50,000 bond.
Which, honestly, when analyzed against the severity and the sheer volume of the charges, is statistically anomalous.
It's shockingly low.
It really is. Bond is generally designed to ensure a defendant returns for trial and to protect the public. Setting it at $50,000 for over 40 severe felony charges involving a minor, that's a decision that falls well outside standard judicial risk mitigation.
Now, Judge Elmore did pair that bond with a formal no-contact order, but, we need to talk about what that actually means in the real world.
Yet a no-contact order is a legal mechanism. It's a piece of paper signed by a judge instructing a defendant not to communicate with or approach a specific person.
Right.
But it is vital to understand that it is fundamentally a legal fiction. It relies almost entirely on the honor system of the accused to obey it.
Which, in this case, is a guy with 43 felony charges.
Exactly. If they choose to violate it, the order itself cannot physically stop them. It does not erect a force field. It does not stop a truck from driving down a highway.
Well,
It merely provides a legal mechanism to penalize them after the fact, and that's assuming law enforcement can intervene in time.
and that piece of paper proved entirely useless on the night of October 8th, 2024, which brings us to the night of the actual confrontation.
Yeah, this is where things escalate.
So Aaron Spencer, who is an Army veteran and a local farmer, he is asleep in his home. Around 1 o'clock in the morning, his dogs start barking wildly. He gets up to investigate, checks his home, and goes to his 13-year-old daughter's bedroom.
And this is every parent's worst nightmare.
It is. He opens the door, and her bed is empty. And someone has actually placed a stuffed animal under the blankets to create the illusion that she is still asleep.
The psychological terror of that specific moment is profound. The father knows exactly who the primary threat to his daughter is, and he knows that the state has basically allowed that threat back onto the streets.
So Spencer's very first action is to call 911. He reports his daughter missing. But he doesn't just sit in his living room waiting for a patrol car to show up.
Of course not.
Right. He arms himself, gets into his truck, and begins scouring the dark rural roads of Lanoke County. And out there in the pitch black, he spots a vehicle. He approaches it, and he realizes that Michael Fosler, the 67-year-old man out on bond, is behind the wheel.
And his daughter's in the car.
Yeah, his 13-year-old daughter is sitting right there in the passenger seat.
From a legal perspective, this is the ultimate manifestation of the system's failure playing out in real time. The state assured the family that the legal framework would protect them, right? That the bond conditions would suffice.
They promised.
And now, the father is staring directly at the physical proof that those assurances were completely meaningless.
So the arrest affidavits and police reports detail what happens next. Spencer doesn't just trail the vehicle and act as a spotter for the police. He takes aggressive physical action.
He engages.
He uses his own truck to physically force Fosler's vehicle off the highway, bringing it to a sudden stop. Now, according to Spencer's statements to the police, in the immediate aftermath of the crash, he saw his daughter attempting to escape from the passenger side of the truck.
Okay.
But crucially, he stated that Fosler physically grabbed her to prevent her from getting away.
And we really need to pause on that specific detail because it is the absolute linchpin of the entire legal case that follows.
Because it changes the nature of the crime.
Completely. When Fossler allegedly physically restrains the child, the legal nature of the encounter instantly shifts. It is no longer just a violation of a court order or even custodial interference.
Right.
In the eyes of the law, that physical restraint transforms the situation into an active, ongoing kidnapping.
And the sequence escalates rapidly from there. According to Spencer, Fossler exits his truck and appears to have something in his hand. Spencer opens fire. He shoots Michael Fossler 15 times.
15 times.
Yeah. Fossler is pronounced dead at the scene, and immediately after the shooting, Spencer gets back on his phone, calls 911 a second time, and reports exactly what has just transpired.
You know, that secondary 911 call is highly relevant in these types of cases. Defense attorneys routinely point to a client's immediate notification of authorities as an indicator of their state of mind.
Like he wasn't trying to hide it.
Exactly. Fleeing a scene is generally interpreted as consciousness of guilt. Staying at the scene and immediately reporting the action strongly implies that the individual genuinely believed their actions were necessary and legally justified under the circumstances.
But I'm sure you listening right now are probably getting stuck on one specific detail 15 times.
It's a lot around.
When you hear that someone emptied a magazine to another person, that stretches the common understanding of, neutralizing a threat. To a lot of people, 15 shots sounds like raw, unadulterated vengeance.
It does.
It sounds less like stopping a kidnapping and more like an execution born out of parental rage. So how does the criminal justice system separate a justified, chaotic response to an active threat from illegal, premeditated vigilante justice?
Well, that is the precise friction point the prosecution zeroed in on.
Yeah.
If we look at this strictly through the lens of the state's prosecuting attorneys, they decided to charge Aaron Spencer with second-degree murder.
Not first degree.
Right. To understand why, we have to look at how Arkansas defines that specific charge. Second-degree murder is distinctly different from first-degree murder because it does not require the state to prove premeditation.
So they didn't think he planned it.
No, they didn't have to convince a jury that Spencer woke up that morning, planned a murder, and then executed it.
They just have to prove that his actions in that specific moment crossed a legal line.
Precisely. Under Arkansas law, to secure a second-degree murder conviction, the prosecution must prove that the defendant acted under circumstances manifesting extreme indifference to the value of human life.
Extreme indifference to human life. But how does the state argue that in this context, given who Fossler was and what he was actively doing?
The state's theory of the case essentially stripped away all the emotional context and focused purely on the mechanics of the encounter.
Okay, so they're looking at it mechanically.
Yes. Their argument would posit that Spencer had non-lethal options available to him. They would argue that he could have remained in his vehicle, followed Fossler from a safe distance, and maintained an open line with 911 dispatchers.
Like giving turn-by-turn directions.
Right, providing coordinates until marked deputies could execute a felony traffic stop. By making the conscious choice to use his 2-ton vehicle as a weapon to force a crash, and by subsequently firing 15 rounds, the state argued that Spencer abandoned his role as a witness or a protector.
One became the aggressor.
Exactly, acting with an extreme indifference to whether Fossler actually survived the encounter.
Essentially, the prosecution is enforcing the idea that the state holds the absolute monopoly on violence. They are saying that citizens, no matter how righteous their anger or how profound their fear, are legally obligated to de-escalate and defer to authorities whenever it is physically possible to do so.
And that is the bedrock of criminal law. I mean, this system cannot function if citizens are permitted to operate as independent arbiters of lethal justice, regardless of how abhorrent the underlying crime might be.
Right, the law is rigid.
The sheer violence of the encounter, the vehicular ramming followed by 15 gunshots, that provided the state with the evidentiary basis to argue that Spencer crossed the line from justified defense into criminal offense.
But Spencer's defense attorneys, Aaron Casanelli and Michael Kaiser, they are looking at the exact same sequence of events and applying a completely different legal framework.
A very compelling one, too.
Their argument essentially says, look, the state wasn't there. The state failed to stop this predator from taking her. The father had to act. And this brings us to a fascinating legal labyrinth. How does the law actually define self-defense, particularly when you are using lethal force to protect a third party, in this case, your own child?
It's complex.
We hear terms thrown around online constantly, right? Stand your ground, castle doctrine, but the actual legal mechanisms behind them are highly specific.
They are incredibly specific, and they vary dramatically depending on your jurisdiction. To understand the defense strategy here, we need to dive deeply into the U.S. Law Shield materials, which provide a really comprehensive breakdown of how deadly force is adjudicated.
Okay, lay it out for us.
The entire concept of self-defense rests upon a foundational legal concept known as the objective reasonable person standard.
The reasonable person. That hypothetical figure seems to carry the weight of the entire judicial system on their shoulders.
They really do. The law fundamentally recognizes that a jury cannot telepathically peer into a defendant's mind to know exactly what level of terror they were experiencing in a chaotic, adrenaline-fueled moment.
It's impossible to quantify fear.
Exactly. If the standard were purely subjective, simply asking, did Aaron Spencer feel he needed to shoot? Almost any action could be justified by a claim of fear.
Sure.
Therefore, the law utilizes an objective test. It instructs a jury to imagine a hypothetical, entirely rational individual. The jury is then asked, would this objective, reasonable person, standing in the exact same shoes as the defendant, possessing the exact same knowledge at that exact moment, believe that the use of deadly force was immediately necessary?
But the law doesn't let you use deadly force just because you reasonably believe someone is going to, like, shove you or punch you, right? The threat has to meet a specific threshold.
Absolutely. The authorization to use lethal force is one of the most severely restricted actions in civil society. A reasonable person must believe that deadly force is immediately necessary to prevent very specific outcomes.
Like death.
Generally, yes, death or serious bodily injury. However, the law also explicitly carves out the prevention of certain violent felonies. In Arkansas and many other jurisdictions, the law explicitly authorizes the use of deadly force to prevent a kidnapping or to prevent sexual intercourse compelled by force or threat.
Okay, and when you map that specific legal carve-out onto facts of this case, you see exactly how Spencer's defense is threading the needle here.
Oh, perfectly.
They aren't walking into court arguing that he shot Fossler out of rage or because he is a bad guy who deserved it. They are anchoring their entire defense to the specific claim that Fossler physically grabbed the daughter to stop her from leaving the truck.
That's the key.
Right. That physical act transforms a creepy violation of a no-contact order into an active, ongoing kidnapping.
And we have to view that kidnapping through the lens of what Spencer knew at the time. He wasn't witnessing a random stranger grab his daughter. He was witnessing a man who was already facing 43 felony counts related to the sexual abuse of that specific child.
He knew exactly what the stakes were.
Exactly. When the defense presents the objective reasonable person test to a jury, the framing is incredibly powerful. They're asking, would a reasonable father, fully aware of this man's predatory history, watching him physically restrain his 13-year-old daughter on an isolated road at 1 in the morning, reasonably believe that lethal force was the only immediate way to prevent a kidnapping and a likely severe sexual assault?
Framed like that, it is very difficult to imagine 12 jurors unanimously agreeing that a reasonable person would just sit in their truck and wait for the police.
It's a tough sell for the prosecution.
But the state still argued that he had a duty to wait, or a duty to retreat. Which brings us to the historical concepts of where and when you are legally required to back down. Let's trace the origins of these ideas, starting with the Castle Doctrine.
If we look at the historical data provided in the Wikipedia sources, we find that the Castle Doctrine is not some modern invention of the American legal system. The underlying philosophy can actually be traced all the way back to Roman law.
Really? That far back?
Yeah, specifically the Justinian Digest, which articulated the idea that a citizen's domicile is legally inviolable. But the concept, as we understand it today, was formalized within English common law.
Okay, so a bit more recent.
Right. The renowned 18th century jurist William Blackstone codified this in his commentaries on the laws of England, famously stating that a man's home is his castle.
So the foundation of the law is that your home is your ultimate sanctuary.
Exactly. The logic is that if you are attacked within your own home, you have quite literally run out of places to retreat to. You have reached the final boundary of your personal safety.
Makes sense.
Therefore, the law removes the duty to retreat. If someone breaks into your home, you are not legally obligated to try and climb out a back window before you use force to defend yourself. You are legally permitted to stand your ground and use deadly force to repel the intruder.
And then that idea came over to America.
Right. As legal traditions crossed the Atlantic, this concept was deeply embraced by the American frontier culture. where the idea of the pioneer defending the homestead was seen as, an essential right.
But if we apply that to the Spencer case, there's an obvious disconnect. Karen Spencer wasn't standing in his living room when he fired those shots.
No, he
He
wasn't.
was out on a public highway, so the castle doctrine doesn't actually apply to this situation at all.
You have hit on a very common misconception. People frequently use the terms castle doctrine and stand your ground interchangeably, but legally, they are distinct mechanisms.
How so?
Well, the castle doctrine is strictly geographical. It applies only to your abode, your home, and depending on the state, sometimes your vehicle or your place of business. It is a localized zone of protection.
Okay.
Aaron Spencer's defense did not rely on the castle doctrine. They relied on the much broader legal framework known as stand your ground.
Let's clearly define how stand your ground changes the equation here.
While the castle doctrine removes the duty to retreat only when you are inside your specific sanctuary, a stand your ground law removes the duty to retreat in any location where you are lawfully permitted to be.
Any location.
Yes, if you have a legal right to be standing on a sidewalk or sitting in a restaurant or driving on a public highway, you are not legally required to try and run away before you use justifiable force to defend yourself against an imminent, severe threat.
Wow.
And Arkansas happens to be one of 38 states that operate under some variation of a stand your ground law.
To put it in a slightly different way, it's the difference between having a stationary fortress and having a mobile force field.
That's a great way to put it.
The castle doctrine means your physical house is protected. Stand your ground means you carry a legal protective bubble around with you wherever you go. As long as you are legally allowed to be in a given space, that bubble protects your right to defend yourself without having to put your car in reverse and flee.
That concept of a traveling protective bubble is an excellent way to visualize the legal theory. Because Aaron Spencer had every legal right to be driving his truck on a public road in Arkansas, the law states he had no duty to retreat from Michael Fossler before taking action to protect his daughter.
However, the law is still incredibly pedantic about what you are actually allowed to defend within that bubble. We can look at some comparative case law from the sources to illustrate how tightly these rules are wound.
Yeah, the rules are very rigid.
The U.S. Law Shield documents provide some fascinating contrasts, particularly when looking at how different states value property versus life. For instance, if you look at Virginia law, they are explicitly clear that you cannot use lethal force simply to protect an object.
And the landmark case there is Dodson v. Commonwealth. The court established very clearly that while you are permitted to use reasonable, non-lethal force to stop someone from stealing your property, you absolutely cannot endanger human life or cause great bodily harm just to protect an inanimate object.
So you can't shoot a thief?
Exactly. You cannot shoot someone who is running away with your television, and you cannot shoot someone who is trying to steal your car out of your driveway. The law fundamentally subordinates the value of property to the value of human life.
But then, in a strange twist of legal precedent, Virginia law also features the case of Willeroy v. Commonwealth.
Right, the livestock case.
In that case, the court determined that you are legally permitted to use deadly force to protect your livestock from a dog or a wild animal that is attacking them. So, you can legally shoot a dog to save your chickens, but you cannot legally shoot a human being to save your automobile.
It perfectly illustrates the hierarchy of values codified in the legal system. Human life is always the paramount value, unless a human is actively threatening another human life. Property is fundamentally subordinate.
And Spencer's lawyers knew this.
Oh, Aaron Spencer's legal team understood this hierarchy implicitly. They never argued that Spencer was defending his vehicle during the crash, and they never framed his actions as exacting righteous vengeance for Fossler's past crimes.
They kept it very focused.
Extremely focused. They anchored the entire weight of their defense on a single, legally justifiable premise.
Yeah.
He was using deadly force to prevent the violent, active felony of kidnapping. Outside of the home, that is one of the only ways lethal force is legally sanctioned.
So when you lay all these pieces out on the table, you have a father stepping in to protect his child, you have a state operating under a robust stand-your-ground statute, and you have police documentation citing the victim's claim that she was being physically restrained by a known predator.
The pieces are all there.
You would think that this would be a relatively straightforward, albeit tragic, trial. The defense presents their reasonable person argument, the prosecution tries to poke holes in the necessity of the force, and a jury decides the outcome.
That's how it's supposed to work.
But that is not what happened, because the judicial system in Lino County was about to spiral into something entirely different.
The procedural history leading up to the trial is truly baffling, and the central figure in this administrative chaos is Judge Barbara Elmore.
Yes, the very same judge who initially looked at Michael Fosler's 43 felony sexual abuse charges and determined that a $50,000 bond was sufficient.
The exact same one.
She is the judge who was subsequently assigned to preside over Aaron Spencer's second-degree murder trial. And her management of the pretrial phase, it defies standard judicial behavior. Let's break down exactly what she did. As the trial approached, the prosecution filed a motion for a gag order.
Which basically means they wanted Spencer and his legal counsel barred from speaking to the media about the case.
Right. And is that normal?
In the context of a highly publicized, emotionally charged trial, it's not an entirely uncommon request. Prosecutors often seek gag orders to prevent the potential jury pool from being tainted by pretrial publicity.
Okay, so the request itself wasn't crazy.
No, but there is a strict procedural mechanism for implementing one. The defense immediately objected, citing Spencer's First Amendment rights to free speech and his Sixth Amendment right to a fair trial. They formally requested a hearing to debate the merits of the gag order in open court.
But Judge Elmore didn't hold a hearing.
She did not.
She simply bypassed the debate and unilaterally issued the gag order. But she didn't stop there. Without either the prosecution or the defense even requesting it, she took the extraordinary step of sealing the entire case file.
Just completely locked it down.
She essentially threw a blackout curtain over the entire judicial process, preventing the public, the press, and the community from seeing any of the motions, evidence, or arguments being filed.
It was a unilateral maneuver that operated entirely outside standard procedural norms. Courts are fundamentally public institutions. Sealing an entire docket without a compelling, publicly articulated reason is highly irregular.
So what did the defense do?
Spencer's defense team immediately filed an appeal with the Arkansas Supreme Court, and the Supreme Court's response was swift and unusually severe. In May of 2025, the higher court completely reversed Judge Elmore's orders.
They shut her down.
They didn't simply overrule her, they utilized incredibly sharp language, characterizing her actions as a plain, manifest, clear, and gross abuse of discretion. The Supreme Court explicitly noted that her sweeping orders lacked any evidentiary basis.
When a trial judge gets reprimanded by the state Supreme Court in language that strong, you would assume they would immediately course correct and adhere strictly to the letter of the law.
You would certainly hope so.
But Judge Elmore's response was to essentially double down on the secrecy.
It is a fascinating study in administrative entrenchment. 7 months after the Supreme Court rebuked her, and as the rescheduled trial date in January of 2026 approached, she issued a new set of highly restrictive orders.
She just wouldn't let it go.
No. She mandated that physical access to the courtroom would be strictly limited to a maximum of 55 people. She instituted a blanket ban on all cameras within the courtroom, and she explicitly refused to provide any sort of overflow room with an audio or video feed that would allow the public or the media to monitor the proceedings remotely.
She was effectively trying to conduct a shadow trial in a small room. It makes you wonder what the motivation was. Was it an attempt to control the narrative? Was she trying to shield the court from public scrutiny after the initial backlash over Fosler's bond?
It's hard to say what her internal logic was.
Whatever the reasoning, the defense once again appealed to the Supreme Court. And this time, the higher court's intervention was definitive.
Very definitive. Just 48 hours before opening arguments were scheduled to begin in January 2026, the Arkansas Supreme Court took the exceptionally rare step of removing Judge Elmore from the case entirely.
Just removed her. How does that actually work mechanically? Does the Supreme Court just call her up and tell her she's fired?
Well, it operates through a mechanism of supervisory jurisdiction. When a lower court judge continuously demonstrates an inability or unwillingness to follow procedural rules or constitutional mandates, the higher court can issue what is essentially an emergency writ, often a writ of mandamus, or a supervisory order.
Okay, a writ.
Right. And that legally strips the judge of their jurisdiction over that specific matter. The Chief Justice of the Arkansas Supreme Court intervened and assigned a retired jurist, Judge Ralph Wilson, Jr., to take over the docket.
But that must have delayed things.
Oh, massively. Because Judge Wilson had to review the entire case history from scratch. The January trial date had to be scrapped entirely, pushing the trial back by months.
So Aaron Spencer is out on bond, waiting for a murder trial that just got derailed because the presiding judge was removed by the Supreme Court. He is sitting there looking at a system that allowed his daughter's abuser out of jail, arrested him for intervening, and then completely bungled the pretrial
It's
process.
a surreal situation to be in.
And this is the exact moment where the narrative pivots from a legal procedural into a full-blown political uprising.
Correct.
While he is waiting for his new trial date, Aaron Spencer makes the audacious decision to run for Lano County Sheriff.
It's a political maneuver with almost zero historical precedent. I mean, it's unheard of.
He decides that instead of just fighting the system in court, he is going to attempt to execute a hostile takeover of the entire department. He registers to run as a Republican, challenging the incumbent, John Staley. And just to put the pieces together for you, John Staley isn't just a random political opponent.
No, not at all.
He is the 13-year incumbent sheriff who runs the exact department whose deputies responded to the October 8th incident and whose agency ultimately placed Aaron Spencer under arrest for murder.
You have an accused individual actively debating and campaigning against the very law enforcement apparatus that is actively trying to incarcerate him.
It's mind-boggling.
Spencer's campaign messaging was incredibly direct, too. He released campaign materials stating, point blank, "I'm the father who acted to protect his daughter when the system failed."
Right to the point.
Very much so. His platform centered heavily on transparency, systemic accountability, and a specific pledge to create a dedicated task force to aggressively combat sex crimes against children.
And the voters of Lano County didn't just listen, they responded overwhelmingly. The primary election was held in March of 2026.
And the results were stunning.
The results were a landslide. Aaron Spencer, while actively wearing an ankle monitor and facing decades in prison, captured 53.5% of the vote. The incumbent Sheriff Staley only managed to secure 26.5%.
The electorate essentially functioned as an early public jury. They examined the facts of the case, they evaluated the failures of the judicial system, and they cast their ballots in direct alignment with the accused father.
It's a huge repudiation of the current system.
It is. However, we have to look at the structural paradox this created. If Spencer were to win the general election, the prosecuting attorneys who had spent a year trying to convince a jury that he was a murderer would suddenly find themselves working alongside him in the exact same county justice system.
Just awkward hallway encounters every day. But there is a massive legal hurdle standing in the way of that scenario. In Arkansas, as is the case in many jurisdictions, an individual with a felony conviction is constitutionally barred from holding public office.
That's the catch.
Therefore, Spencer's entire political future, not to mention his personal freedom, hinged completely on the outcome of his rescheduled trial. If the jury acquitted him, he was on a glide path to becoming the sheriff. If they convicted him of second-degree murder, he would become a felon, his political victory would be voided, and he would be sent to a state penitentiary.
The stakes for that summer trial were unimaginably high.
But as it turns out, we don't have to speculate on what a jury might have decided, because that highly anticipated trial is never going to happen.
No, it is not.
Which brings us to the stunning developments from exactly 1 day ago. Let's dig into the June 4th, 2026 update. Special Circuit Court Judge Ralph Wilson Jr., the retired judge brought in to stabilize the case, issued a ruling that brought the entire criminal prosecution to a screeching halt.
He ended it.
He formally dismissed the second-degree murder charges against Aaron Spencer.
But the reasoning behind the dismissal is what makes this development so shocking. The charges weren't dismissed because the judge unilaterally decided it was self-defense.
Right.
They were dismissed because of a catastrophic evidentiary failure by the state. Specifically, the Lano County Sheriff's Department, the department Spencer, had just defeated in the primary, lost a critical piece of physical evidence.
What did they lose?
They lost the digital FD memory card that was inside the dash camera of Aaron Spencer's truck on the night of the incident.
They lost the tape, the digital record of the actual event. How does a law enforcement agency just lose a piece of evidence in a high-profile murder case?
To understand the magnitude of this failure, we have to look at how evidence is actually supposed to be handled. When police secure a scene, physical evidence is meticulously documented. It is photographed in situ, collected with gloved hands, placed into specialized, tamper-evident packaging, and labeled with a unique case number.
It's a rigorous process.
Highly rigorous. It is then physically transported to an evidence locker, where a chain of custody log tracks exactly who handled it, when they checked it out, and when they returned it. For a digital SD card to vanish means that this strict chain of custody was broken at some point within the department.
And Spencer's defense team rightly pointed out that this missing SD card wasn't just a peripheral piece of evidence, like a blurry photo of a license plate.
No, it was central to the case.
They argued that it likely contained the objective visual proof of the altercation. They asserted that the footage would have shown Fosler physically grabbing the daughter, thereby providing incontrovertible proof of the act of kidnapping.
And under legal precedent, specifically rooted in the Supreme Court case Brady v. Maryland, the state has an absolute constitutional duty to preserve and turn over any exculpatory evidence.
Meaning evidence that could prove he's innocent.
Exactly. Evidence that might exonerate a defendant. When the state loses evidence that the defense claims would have exonerated them, it creates an insurmountable due process violation. You cannot put a man on trial for his life when the state itself has misplaced the very evidence that could clear his name.
It is almost impossible to overstate the irony here. The sheriff's department that he just defeated in a political primary managed to lose the single piece of evidence that could have either put him in prison or completely vindicated him.
It's surreal.
You have to wonder what the underlying cause was. Was it just profound, staggering incompetence? Or was there a realization that the footage was going to publicly exonerate Spencer and further embarrass the department, leading to the card quietly disappearing?
Well, while we cannot definitively attribute motive without further investigation, and we're just analyzing the documents here, the legal outcome remains the exact same, regardless of whether it was malfeasance or gross negligence.
But the judge didn't care why it was gone.
Right. Judge Wilson's written ruling was scathing. He acknowledged that taking the step to outright dismiss a murder charge is an extraordinary and extreme remedy. Courts generally prefer to let juries decide facts. However, he wrote that the law enforcement conduct in this instance was, quote, so egregious that dismissal of this case is warranted, because the state effectively destroyed Spencer's ability to mount a complete defense.
Precisely. Judge Wilson ruled that the loss of the memory card, quote, adversely impaired the defendant's ability to defend himself pursuant to these defenses and thus his right to a fair trial. The constitutional guarantee of a fair trial collapses if the state cannot secure the evidence.
So with the stroke of a pen, the murder charges are gone. Aaron Spencer is a free man with no felony convictions hanging over his head, which completely reshapes the political landscape as we look toward the general election in November of 2026.
The dynamic has shifted entirely. Aaron Spencer, the Republican nominee, is now facing the Democratic nominee, Brian Mitchell Sr. To understand the likely outcome, we simply have to look at the voting demographics of Lanoke County. And what do those look like?
Well, based on the electoral data and the sources, this is a jurisdiction where Donald Trump secured 76% of the vote in the 2024 presidential election. It is a deeply conservative electorate.
So, purely statistically speaking, the Republican nominee is the overwhelming favorite. We're not taking any political stance here, just looking at the math provided.
Yes, just looking at the electoral math. You have a Republican nominee who has now been legally cleared of all charges, who has successfully built a massive, highly motivated grassroots movement centered on protecting children and holding a failed bureaucratic system accountable.
He has a lot of momentum.
Barring an unforeseen development, he is positioned to win the general election and assume control as the top law enforcement officer in the county.
It really is one of the most incredible arcs we have ever analyzed on this show. Let's just step back and look at the sheer whiplash of this timeline. It begins with the profound systemic failure of the justice system.
The total breakdown.
A judge looks at a man with 43 felony sexual abuse charges and allows him out on a negligible bond, completely failing to keep a documented predator off the streets. When that system fails to protect a 13-year-old girl, her father steps into the void.
He does what the state wouldn't.
He engages in a violent, chaotic, but ultimately legally justifiable intervention to save her from what the law defines as an act of kidnapping.
And that intervention is then followed by a severely bungled judicial process. A trial judge attempts to implement unprecedented secrecy, gets swiftly ousted by the state Supreme Court, and the local justice system seemingly attempts to crush the father for exposing their initial failure to protect his child.
Which triggers a political uprising. The accused father runs against the institutional establishment, wins the primary by a massive margin, and then watches the state's criminal case against him completely evaporate because the very police force he is campaigning to take over manages to lose the most critical piece of evidence.
It's a masterclass in institutional collapse from top to bottom.
It really is.
And beyond the sheer drama of the events, it serves as a profound stress test for the social contract itself. It tests the absolute limits of what we expect from the law and conversely, what the law expects from us as citizens.
How much can we really rely on it?
Right. We are conditioned to rely on the system. We are told to call 911, to let the courts handle disputes, to trust the process. That reliance is the foundation of a civilized, orderly society. But when that system demonstrably fails to protect the most vulnerable people within it, when a piece of paper is the only barrier left between a predator and a child, human nature will inevitably and forcefully take over.
The pressure cooker has to vent.
Exactly. And when human nature takes the wheel, the resulting actions, while deeply instinctual and protective, often crash violently against the cold, rigid statutes of the criminal code. The law is designed for order. Human instinct is designed for survival.
Which leaves you with a really profound, somewhat unsettling question to mull over. The justice system in Lenokiani entirely failed to protect Aaron Spencer's daughter. It then spent a year and a half attempting to severely punish him for stepping into the gap that their failure created.
And in the end, it defeated its own prosecution through sheer, staggering incompetence.
So I leave you with this thought. When the designated protectors fail so spectacularly, and the strict letter of the law attempts to punish citizens for engaging in self-help, where does true justice actually reside in a modern society?
It's a heavy question.
Is it found in the meticulous paperwork of a courtroom? Or is it sometimes found on a dark highway at 1 in the morning? We'll leave you to think about that. Thanks for joining us on this deep dive. Don't forget to leave a like and subscribe to the channel if you want more deep dives like this.